Hello, this is Dr. Prasad Podilam. This is a class series on research methodology and intellectual property rights. This is 2022 scheme. Uh, the subject code is BRMK557. I'm starting with the module 3 because module 1 and module 2 are the same compared to the previous syllabus, 2021 scheme syllabus, which was 21 RMI 56 or so. Okay, so 1 and 2 classes are the same, so I'm not repeating it. It is already there in my YouTube channel playlist of research methodology and IPR. You can get it from there. Okay, so continuing from module 3, module 4 and module 5 modified little bit. So I'm not going in depth because most of the topics are the same. Some of the topics which are there in fresh, combining those or giving more importance to that. I'm preparing this video class series. Okay, so before I start something on the class, I would like to request you people, those who are watching my YouTube videos, please subscribe. Your subscription on this, what is the support that I am getting, and that is the thank I am getting from you for my effort which I am taking to prepare this materials and delivering it in a way that I am doing. So this is module 3 of BRMK557 of Visheshwara Technological University. You can check the syllabus of previous years. Module 1 and module 2 is exactly the same. Module 3 they did modification. Improvisation is done in the syllabus. Okay, so based on that, I'm taking the topics wise and preparing, taking and giving the question and answer for that. Okay, so now moving on to the topics which I am taken here. That is role of IP in economic and cultural development of society. IP governance, IP as a global indicator of innovation, origin of IP, history of IP in India, major amendments in IP laws and acts in India. So based on that, a question is framed connected to course outcome 1 with a level of 2. Explain the role of intellectual property in the cultural development of society. So that is the term which is there in the syllabus as such. Therefore, answer the scheme I'm giving, and I'll just try to elaborate it. Okay, so IP helps protect the cultural heritage and creativity by ensuring that cultural products such as the literature, the art and music, their examples, are legally protected. So the IP, when we say IP, that is the intellectual property. The IP laws make sure that the important cultural things like the books or paintings or the songs, they are safe and cannot be copied without a permission. It means that someone who creates a book or a piece of art or a song has the legal right to decide how it is used, and no one can steal it or claim it as their own. So imagine that one of a very famous artist, he creates a painting which represents his cultural or culture or his country. With the IP protection, by default, no one can copy this painting and sell it out without asking the artist. So this keeps the painting unique and special. Okay, so moving to the second key point, it incentives creativity by giving creator exclusive rights to their works, promoting further innovation. So when people know that their creative work will be protected, they feel encouraged to create more. So IP gives them the exclusive right, meaning only they can decide what happens to their work. So this, it rewards the system. It encourages the people to think of new ideas, and because of they know others cannot steal or misuse it, or they cannot misuse them. So, for example, if I say a movie director who makes exciting new films, They know that no one can copy or sell the film or movie without their permission. So they feel safe to create more movies. So this protection it pushes them to come up with better ideas and keep making new movies. Right. IP ensures that cultural knowledge and creativity can be monetized, which helps sustain economic development within a society. That means IP allows the intellectual property. It allows people to make money from their creative work. So when artists or writers or the musicians they can sell their work and get paid for it. This helps them make a living when they earn the money. So it also helps the economy grow because they spend money on other things like food, homes, or clothes. So this way creativity and cultural work can help the whole society. Means if a famous author he writes a popular book series, because of the intellectual property he can earn money even every time when someone buys the book, or watches the movie based on the book, or buys the merchandise like the t-shirt with quotes from the book. The author can make a living from their creativity, and the economy also benefits because people spend money on these products. That means IP protects the cultural creation like books, arts, and music, so the others cannot steal them. IP encourages people to create more by giving them the control over their work. It also helps creators to earn much money from their work, which supports them and grow the economy. Moving to the topics, conditions for obtaining a patent protection. To patent or not to patent an invention, rights associated with the patents, inventions eligible for patenting, non-patentable matters. Okay, so is based on that a question is framed with connecting to course outcome 3 level kept as 2. What are the key conditions that must be met to obtain patent protect for an invention? Okay, answer scheme starts. The invention must be a novel. It should not be previously known or used. Means for something to be called as an invention, it must be new. So this means no one else should have already made it or used it before. So if it has been shown or used by someone else, it cannot be called as an invention. So imagine someone invents a new type of mobile phone which can also purify water. Just an imagination telling. So no one has if no one has ever made or used a phone like this before, it is considered a novel one, meaning it's new. But if someone else had already invented a similar phone, which can be used as a phone as well as it can purify the water, for tap water it can take and purify and give, then it will not be a novel one. So just to understand that I explained something different, new one, which is not, it was not there. Mobile phone was there earlier, but the mobile phone which can also use to purify water is a new invention or novel. So novelty should be there. So the invention must have industrial application. It should be useful in some form of the industry. So the invention it should not be just an idea or a theory. It should be something that people can use in their real life, especially in business or factories. It must have a practical purpose and be able to help to solve a problem or make something better. Just think about a new type of solar panel which can produce electricity even during the cloudy days. So this invention could be very useful for the energy industry, as it can help people to produce more and more electricity in an efficient way. Okay, so since it is helpful and can be used in industry, it has an industrial applicability. That is the word which is used. Third point, the invention must involve an inventive step. It should not be obvious to someone skilled in the relevant field. So the invention must be something new and not too simple. If someone who knows a lot about the topic, means someone means who is an expert who knows about topic, could easily think of the same idea, then it is not considered an inventive step. It need to show some creativity or innovation that experts wouldn't easily figure it out. Let's say a car company, it invents a new kind of tire which can repair itself when it gets a hole. So this idea is not something that all car experts would easily think of. It is very creative and it involves new things, so it has an inventive step. The fourth point, the subject matter should be patentable under law, not falling under non-patentable categories like abstract ideas or laws of nature. Not everything can be patented. For example, we cannot patent an idea which comes over our head suddenly, like just a mobile phone which purifies water. It cannot be patented as such unless until I give a scientific fact or something which is natural, like the laws of gravity. So only certain types of things can be patented, like the machines, medicines, or new products. If someone discovers a new natural plant which can cure a disease, they cannot patent the plant itself because it's part of the nature. But however, if they create a new medicine using that plant, the medicine can be patented because it is a new product made by human. So this means the invention must follow the rules what can be patented. So the invention must be new, it must be useful, it should involve something new things or new thinking, and it must follow the patent laws, the laws given by the patent. Now moving to the topics, avoid public disclosure of an invention before patenting. So that itself is the point. Process of patenting, which includes the prior art search, choice of application, patent forms, jurisdiction of filing patent applications, publication, pre-grant opposition examination, grant of a patent, validity of patent protection, post-grant opposition, commercialization of a patent. If that question is framed, outline the steps involved in the patenting process from filing to the grant of a patent, connecting to course outcome 3 with a level of 2. Okay, so answer scheme, prior art search. Prior art search, that is searching for existing patent or publications to ensure the invention is new or novel. Before we try to patent something, we need to check if someone else has already made or published the same thing. So this search helps to see if the idea is truly new, called the novel. Imagining that we invent a new type of eco-friendly plastic. Before we apply for a patent, we do a prior art search to make sure that no one else has already made the same plastic. If someone else has already done, then we cannot get a patent for that idea or that work. Filing applications, submitting the patent applications with all necessary details and forms. After we are sure that our invention is new, we need to officially submit an application. So this application includes details like how our invention works, why it is new, and any forms required by the patent office. For example, after inventing a new that solar panel, efficient solar panel, we fill out a form which explains how the solar panel works, why our solar panel is very unique, and then we need to submit it to the patent office. So this process is called filling the applications. Now, jurisdiction selection, deciding where the patent will be filed, either it is national or international. So we have to decide in which countries or regions we want our patent to be protected. So we can apply for a patent in just our home country or even in other countries also. So if you are an inventor in India and we want our invention to be protected in both India and the United States, we need to choose those two places when we apply for the patent. So this is called jurisdiction selection. Now the patent publication is published after specific period. After we submit our patent application, then it won't stay secret. So the patent office will make it public after a few months. That is called publications. Okay, so you might have seen many institutions they call that our patent got published. Means whatever we submitted that they made it to the public. Imagining that we file a patent application for a new type of smartphone battery. After a few months, the patent office it publishes our application so that the other people can see that we are trying to patent that invention. If they have any objection, they can object. Anyone can object. Now, pre-grant opposition, allowing third parties to oppose the patent application before the grant. So before patent is granted, the other people have the chance to object if they believe or if they think that the invention should not be patented. And this is called the pre-grant opposition. So if a company see our patent application or the what one details we are given for patent granting, which is already published, which is a new type of invention, for example, new type of shoe, which they believe that very too similar to our product, their product, our product is having the details. That means their product and our product are almost having similarity. So they can file a pre-grant opposition to stop our patent from being approved. Okay, now the next point, examination. The patent office it examines the application for its novelty and for the potentiality. So the patent office it reviews our application to make sure that the invention is new, useful, and it is not obvious. They check if it meets all the rules of patentability. After we apply for a patent on a new medical device, the patent office it examines our application to see whether it is really new, whether it meets all the legal requirements or not. Next point, that is grant of patent. If all criteria are met, the patent is granted. If patent office finds that our invention is truly new, it is useful, and it meets all the rules, then they will approve our patent, and there is no objection also if it is there, then they will grant. This means we get the rights to our invention. After means they grant us the patent, that what it does it mean. Now last point, post grant opposition. It allows objections even after the grant. So even after we get to the patent, other people can still challenge it. This is called post grant opposition. So that smartphone battery only take example. We have the patent, we got the patent for our new type of smartphone battery. But later another company, they think that we copied their idea, they can still file a, we called a post grant opposition, and in order to cancel our patent, this you can say that they have already their patent, it is patented, and ours is a second time same thing is getting patented, means ours will be getting cancelled. So you can say that prior art search is needed, filing application, jurisdiction selection, publication, pre-grant opposition, examination, grant of patent. These are the points needed here. A post-grant opposition. Okay, now moving to the next topics. Patent infringements, enforcement of patent rights, types of patent infringements like literal, indirect, remedies like injunction, account of profits, need for a patent attorney or agent, international aspects, can a worldwide patent be obtained like that, and do I need a first to file a patent in India? This is what there in the syllabus. Okay, now the question which I framed is what are the remedies available in case of patent infringement? It's connected to course outcome 3 with a revised Bloom's taxonomy level of 2. So first point, that is injunction. A court which orders to stop the infringing activity. An injunction, it is when the court tells someone to stop doing something which is illegal, like using someone else's invention without permission. So it's like a strong warning from the court saying you must stop immediately. Okay, so imagine that we have a patent for a special kind of water filter. Another company, they starts making the same kind of filter without our permission. Then we can take them to the court. The court will give them an injunction, not injection. It is injunction, ordering them to stop making the filters until the issue is resolved. Okay, now the court will inform the concerned person to check whether it is real or not. Then creating further damage, the court will interfere and injunction will be given. Okay, now second point, account of profits. The infringer is required to pay profits made from the infringement to the patent holder. That means if someone illegally uses our invention and makes money from it, then the court can order them to give us the profit they made from that, using that. So this is called the account of profits. Now third point, that is damages. The patent holder, he may receive monetary compensation for losses due to infringement. The damages are the money that we receive if someone has used our invention without permission, and it causes us to lose money. So it's like being paid back for the losses. Suppose we are going to sell 1,000 units of our new smartphone technology, the battery maybe. So, but another company, they copied it and sold it first. causing us to lose our business. So the court may order that company to pay us the damages, which is the money we lost because of their action. Legal costs. The infringer may be ordered to pay the legal cost of the patent holder. Legal costs are the expenses for hiring a lawyer, going to the court. If we win the cases, the court may order the person who copied our invention, he is called as the infringer. He has to pay, the infringer has to pay us the legal fees what we spent on the lawyer. Okay, so we have to hire a lawyer to go to court. With many of the movies and all, it is possible, but other times, most of the time, like this type of patent issues and all, it is better to hire a lawyer to go to court to fight against someone who copied our invention. So this court may tell the other company or the infringing company to pay all the money that we spend on our lawyers and the legal processes. These are our legal costs. Okay, so now we're moving to more topic, few more per topic. Patent related forms, fee structure, types of patent applications, commonly used terms in patenting, national bodies dealing with patent affairs, utility models. Okay, so identify and describe the role of any two national bodies which involved in patent affairs in India. Connecting to course outcome 3, level of question is 2. Okay, answer scheme. The patent officer responsible for receiving the patent applications, conducting examinations and granting the patents. Okay, so the patent office, it is a government office where people go to apply for a patent. A patent is a special right that stops others from making or selling our invention without our permission. So the patent office, it checks the applications to make sure that it will meet all the rules. If everything is correct, then they give the patent to the inventor. Suppose we invent a new type of bicycle which folds up in a unique way. So to make sure that no one can copy our invention, we go to the patent office and fill out the patent applications. The patent office will look at our applications. They will check if our bicycle is really new and compared to other bikes or other bicycles, ours different, and they will find that our invention is original and it meets the criteria, and then we will get a patent which allows us to be the only one who can make and sell this type of bicycle which can fold completely. Okay. Second point, intellectual property appellate board, IPAB. It handles disputes and appeals related to patents, including oppositions and cancellations. The IPAB, it is a special board which helps to solve the problems and the arguments about a patent. If someone disagree with a decision made by the patent office, they can ask the IPAB to review the case. This IPAB, it will handle the issue like a disputes over who should have the patent or whether the patent should be taken away. Let's say the bicycle, we got a patent for our unique folding bicycle, but another company believes that we stole their idea and they want to cancel our patent. So they can take their complaint to the IPAB. The IPAB will look into the case carefully and decide whether our patent should stay or should be cancelled. Similarly, if we think that another company patents patent is invalid because it is not new or original, we can also take this issue to the IPAB to get a fair decision. I think that's about the module 3. Hope I have covered the entire thing in a very short way, because detailed one it is there already there in the playlist. Only subject code is different there, but the terms which are not there in the previous syllabus, that is covered here. So please do share this video to others. This is for the commonly for the 5th semester students of Visvesvaraya Technological University. Please do share, please like the videos. Comment box again I am closing it because there is nothing to comment. Just watch it. If you feel it's good and points are there, you share it to others. I'm not accepting any comment from here onwards because I don't have time. I have to keep on preparing new topics than commenting it. If anything is there, you can inform me over WhatsApp. So once again, thank you very much for watching my videos. Thank you.